Welcome to the panel on case studies in the use of history in constitutional interpretation. My name is Liz McGill. I have the role of being moderator, but I'm also the dean, and I want to thank you for being here. I hope it's been a productive conversation for all of you. We're delighted to have this conference, and many, many compliments to Michael McConnell and Judd. Where did you go? And the amazing Judd Campbell, who has done tremendous work in bringing this conference off. The Constitutional Law Center at the law school, I feel like, presents us one intellectual feast after another throughout the course of the year with speakers and conferences like this, and it's a huge asset to the institution. So thank you so much for putting on this conference, Michael and Judd. So our topic, as I said, is the specific case studies of the use of historical sources to inform constitutional interpretation. We have a fabulous group of panelists who I think in this room probably don't need an introduction. Let me say just a few things about them. Jack Rakoff will lead us off. Jack is the William Robertson Co-Professor of History at Stanford University. He's a specialist in the American Revolutionary period and the origins of the Constitution and the history of the interpretation of the Constitution. He is both a prolific and prize-winning historian. He's the author of 8 books, including 1, Original Meanings, that won the Pulitzer Prize in History. Jack is going to speak to us about the Second Amendment. Eugene Volokh will follow Jack. He is the Gary Schwartz Professor of Law at UCLA Law School. Prolific is sort of an inadequate word to describe Eugene, I think. He is super prolific, perhaps might be the proper word, or when you look up in the dictionary the word prolific, there may be a picture of Eugene that appears. He's written several books, hundreds of articles, and thousands of other writings. Polymath is another word to describe Eugene. He's written in a dizzying array of subjects, from free speech to tort law to family law to copyright to constitutional legal theory to criminal law, as well as humor writing and fiction, and that's just a small percentage of the list of topics Eugene has written on. He, too, will talk about the Second Amendment. Michael Ramsey will be the third speaker. He's at the University of San Diego Law School. He's held several distinguished chairs at USD, and most recently the Hugh and Hazel Darling Foundation Professorship. He's the director also of the International and Comparative Law Program. I can't resist saying that Mike has a JD from Stanford Law School. He's the author of the Constitution's Text in Foreign Affairs, an influential and widely cited book, and the editor of other books. He's written extensively on the historical and textual meaning of the Constitution, most recently on the original meaning of the Supremacy Clause of the Constitution. I think he's best known for a lot of work he's done on executive authority over foreign affairs and the war powers and the historical and textual understanding of those provisions. Mike will not talk about the Second Amendment. He will instead offer us a variety of other case studies where history does or does not inform constitutional interpretation. He will talk about the Fourth Amendment GPS tracking case, the First Amendment case on violent video games, and more generally the use of history or not in the interpretation of a separation of powers and federalism provisions of the Constitution. The rules are that the panelists will talk for 12 to 15 minutes each. That will leave some discussion, some time for back and forth between and among the panelists, and also questions from the group here so we can have a dialogue. Then we'll take a short break before the next panel. I think the plan is we'll end at about 2:35. So, Professor Rakoff.
Good. First off, I want to say that it's hard for me to talk about this subject without being somewhat autobiographical in terms of my interest in it. It's one of those occasions where I have to feel I want to explain where I'm coming from and how I got into this area. I was a little surprised when Mike and Judd asked me to be on this panel to monitor the Supreme Court. I'm mostly an 18th century historian. I do teach constitutional history, but I am not a con law guy. I think of myself more as a student of constitutionalism more generally. When I teach classes, I don't really spend much time looking at opinions or trying to parse their logic or their substance. My conception of constitutionalism is either somewhat broader or somewhat different from what preoccupies real practitioners of con law. But I have been very much interested in the subject of the Second Amendment, and which became for me a kind of application of a set of problems I set myself to working on, or at least thinking about actually 40 years ago, and then to working on more actively about 30 years ago. And so I want to say just something by way of introduction about that. When I was in graduate school back in the early 1970s is when I first started getting interested in the question of original meaning. And the inspiration for that was essentially events of the time. I was interested in war powers issues. I was interested in the impeachment of Richard Nixon. I was a member of the Reservist Committee Against the War, which filed a very interesting suit against Secretary of Defense Schlesinger, arguing that members of Congress holding commissions in the military reserve should be required to resign either their commissions or their elective office. And I just started thinking in a kind of casual way, gee, it's kind of curious to talk about the original meaning of the Constitution. That sounds to me like a historical problem. How would you do it? I didn't do it for a while because I had, another project to finish, my dissertation, and a book to publish. But when I came to Stanford, I started working on it again actively, and I published a long article on the treaty clause. And then after that, the other project I thought I'd worked on that faded a bit in my interest, and at the same time, the debate over originalism erupted in full public force in 1984. So I kind of moved in a different direction and started thinking about, working out what I think of as my model for originalist inquiry. So my point of departure here is when I think about original meaning, when I think about, or I should say, when I think about recovering alternatively the original meaning, the original intention, or the original understanding of the Constitution, that's to say the meaning of the text, the purposes of its authors, and the understandings of its ratifiers. I set this as the kind of problem that historians ought to address, and to which I feel we should contribute something. I had not anticipated, maybe I should have been smarter, I had not anticipated this would actually give me a whole new basis for pursuing a different career, but one of the nice things about the Constitution is it contains what I like to call sleeper clauses. Clauses that kind of lie there inert and then kind of spring into action because some controversy emerges, so like the recess appointments power would be a nice example, and I know we have something coming this week to talk about that. In my case, it turned out that after my book came out in '96, the first really hot issue to come along was the impeachment of Bill Clinton, and so actually I wound up testifying in the House Judiciary Committee on this, and then I wound up writing a few briefs in the last decade. One involving the Pennsylvania reapportionment case, the second involving Heller, D.C. versus Heller, and the second involving Hamdan. Hamdan, and then D.C. versus Heller. The gun control case coming out of Washington. So I hadn't thought much about the Second Amendment until about 2000, when I went to a conference held in Chicago by opponents of what was coming to be called the standard model of the Second Amendment, the self-propagating, self-fulfilling, self-congratulatory term used by Glenn Reynolds to describe the kind of NRA types, and many of them actually are NRA types, literally as well as figuratively. So I started getting interested in the issue, and I started research and published an article that I'm rather proud of about which I call the Second Amendment, the highest stage of originalism, quoting Lenin. I know Gene just had something up about Trotsky or whatever, so I was kind of punning on Lenin. And so when the Heller case came along, having done a couple other briefs, no one approached us. I did have the idea that historians who thought as we did should organize a brief, and so I reached out to a set of friends and colleagues who had worked pretty specifically in the area, including Saul Cornell, and I asked them in effect to be contributors to the brief. One of the things I learned in writing it, though, is that a brief has to have one author. So it's a little bit of chutzpah, but I think it's not inappropriate for me to say that I'm the actual author of the brief with some significant contributions from my colleagues. The brief was cited in dissent by Justice Stevens. I think Justice Stevens' dissent actually relies more on our brief than his opinion reveals, but that's fine. So let me just offer a few thoughts on how I read D.C. versus Heller in the light of my interest in originalism and our larger interest in the role of history. I went back last night and I reread Justice Scalia's opinion for the majority. I hope Gene will say something about this. I find it a very difficult opinion to read. I mean, I think in terms of craftsmanship, and anybody in the audience is welcome to correct me on this, but I actually find it a very difficult opinion to read because it seems to me Justice Scalia spends an awful lot of time going back and forth from the arguments he wants to make to the criticisms that he wants to address, and the flow of his thought struck me as being somewhat ragged. And I don't think it's the easiest brief, particularly if you're not a lawyer and you're not used to reading these opinions and really knowing technically how to decipher them. It's a tough opinion, I think, to decipher. but not in terms of its bottom line. I think the bottom line is interesting, A, because of the basic holding, recognizing the constitutional right to firearms for purposes of self-defense within the home, and B, because I think it well illustrates the dominance among originalists of public meaning / semantic originalism. I don't think it does so perfectly, maybe because the opinion seems to be a little ragged, but even so, most of the moves that Justice Scalia makes, or most of the analytical techniques he deploys in his decision, are essentially public meaning kinds of moves in relationship with the preamble to the main part, and so on. Extended analysis of what do we mean by keep and bear, and how these two verbs relate one to the other, and how do they appear in other kinds of sources. By contrast, what I think of as the legislative history, what I think of as the political history of the Second Amendment appears really, I won't say en passant, but it appears in a fairly diluted, not very sustained form. By contrast, what we did in the brief, and what I think Justice Stevens largely did in the dissent, was to try to make actual sense of why the Second Amendment was adopted. Making actual sense of why the Second Amendment was adopted depended, I think Justice Stevens and the other justices who joined his dissent agreed, depended very much on understanding what was at issue, what was being discussed, what was actively being disputed, what was controversial in the discussions of 1787, 1788, both at the Federal Convention, both in terms of what I call the intentions of the framers, and in terms of the public debate that followed, or what I call in my book and have called since the understanding of the ratifiers. So one of the things that's interested me about the comments so far, I think, including Keith's remarks at lunchtime, that the understanding of the ratifiers, which by many theoretical claims is central to what is it that makes including claims made by James Madison. What is it that makes the Constitution supreme law? It seems to me that's kind of disappearing, or that's kind of, we're back to intention without understanding. We're back to the purposes of the authors rather than the understanding of the ratifiers. That's a little bit puzzling because the strong legal theory of originalism, and I think maybe, Mike, this ties into your supermajoritarian arguments, I suppose it must, has to depend upon the idea of the exceptional requirements needed to make the Constitution the supreme law of the land. How is it that you get it ratified and part of the Constitution? And of course, the major problem that I think all the reigning generation of originalists have encountered is that once you start talking about an open-ended public debate of the kind Americans had in 1787, 1788, or arguably, if I follow Bill Nelson's work in 1866, 68 on the 14th Amendment, is it's too open-ended, it's too uncertain, there's lots of opinions out there. There is no algorithm available to solve any kind of Condorcet-like problem of knowing which view was dominant, which view was inferior, which one gained a consensus. This is fine for historians. It actually makes work for us. So it's like to say anything, anything which doesn't involve the loss of life and makes work for historians is good. So I think, I think on the whole this works. But if you want to come up with a definitive theory of interpretation, at least in the abstract, might be applicable, employable by judges, it poses a bit of a problem. So I think when you read the Heller case, what you see is a kind of really interesting disparity between two forms of originalism. The one that is dominant is the one that Keith talked, I think, in his characteristic way, so well and so comprehensively about at lunch, with all the kinds of variations and permutations thereon. But really emphasizing the linguistic angle, talking a bit about the difference between interpretation and construction. I'm a little surprised that, in fact, Keith, I have to talk more about this, that the constraint hypothesis seems to be dropping out of this. That seems to be kind of a significant development that I haven't made much sense of. But in any case, Justice Scalia's opinion, because it is so largely indifferent to the historical evidence of, what did Americans think they were doing, what were the issues that actually drove the adoption of the Second Amendment, between 1787 and 1791, what problems or what questions did its framers and ratifiers think they were addressing. No one then, notwithstanding Justice Kennedy's brilliant aperçu about bears and Indians in the oral argument, nobody then was really thinking about a private right to bear arms for purposes of self-defense. And actually, in the brief, I went to some detail, not some detail because there's not much to be said. I went into a little detail to show that the 2 or 3 early references in the ratification debates that actually do touch on individual right to bear arms, I think were kind of quashed pretty quickly. I mean, the statement for the Pennsylvania Anti-Federalists that Saul referred to yesterday, the minority, not the majority, the minority dissenters, that was slapped down. That became an object of Federalist ridicule, and essentially disappears from the public discussion. Whereas the argument about the militia, that the right is primarily about the role of the militia in a Republican society, where the militia is a state-based institution, but the federal government has a strong oversight possibility. And the question is, will the militia flourish or wither under the new constitutional regime? That's what people thought they were talking about. That's the issue they thought they were addressing. That's what our brief was meant to explain, what Justice Stevens, in my view, rightly decided. So the interesting thing about reading D.C. versus Heller, putting aside my confusion over the technical proficiency of Justice Scalia's opinion, who am I to judge? No. I have opinions of my own on this, but anyhow. But who am I to judge? It seems to me is what makes the case so interesting. It actually exposes or illustrates where we are. The last thing I'll say, I probably at this point, Liz, about 2 minutes left or 3.
Exactly, Jack.
Yeah, so
Perfect.
I just have this innate sense of time. So one of the things that most interests me about the public meaning version, and this was identified yesterday as being a remaining problem, is kind of, there's so many problems with it. Saul did a good job, at least by my lights. It's hard to know where to begin. But one problem that really intrigues me is who is the interpreter of the language? Who is the person who's supposed to be interpreting the language, and what kind of authority can we invest in that personality? So I gave a talk in San Diego a few years ago, that hotbed of originalism, with which I published under the title "Joe the Plowman Reads the Constitution," which is my best effort at solving this. But I think it goes to a fundamental difficulty: that are we imagining a Constitution being read by a high-powered Yale or Harvard or Stanford-educated law school student with 4 supremely brilliant clerks working for him? One of my students is clerking for Justice Ginsburg, who's a Stanford BA and Stanford Law School grad next year, and I'm very close to her. I'm super proud of this happening. She's well trained in history, so maybe she could do the work. Is it a judicial interpreter? Is it a very refined citizen who's done a lot of reading? One of those many Americans who purchased Blackstone? Is it an ordinary citizen? Joe the Plowman, I think, probably works better there. Exactly who is the interpreter at play here seems to me to be a kind of really difficult issue to get at here. So it's one major problem I have when I think about the linguistic mode is how to do this. The other point I want to say is, and I'm still thinking about how to do this, is I now think I want to come back to this subject and try to write a Dworkinian-like approach on the side of historians to saying, if we could have a historically based version of originalism. I alluded to this yesterday, and maybe the questions will have a chance to say more about it because my time is up. But I'm trying to think, is just as Dworkin argued, rightly or perhaps wrongly, that strong moral arguments have to presuppose a lot of constitutional decision-making. Maybe there is a case to be made, even conceding the historical inadequacy as historians of most judges, for how they might think about telling the story of American constitutional jurisprudence in better informed terms historically than they've been able to do so far. Thanks.
Thanks, Jeff. And we have a technical job here.
So I could have kept
On, I take it? Just image mute.
Image mute, I think.
There we go. All right.
So I'm getting on in years. My hearing wasn't as it should be. So I thought they wanted me to talk about the 7th Amendment instead of the 2nd Amendment. So I realize I'm mistaken, but that never stopped me. So let me begin with the 7th Amendment. And let me begin with the first clause of the 7th Amendment. And it is, in suits at common law, the right of trial by jury shall be preserved. Now, I should say I'm not an originalist. I think I sympathize a lot with originalists. I sympathize some with the critics of originalism. I think they're very interesting questions of what do you do when precedent points one way, originalism points another way, how you update things in light of changed circumstances. I do think, though, that if you're going to care about text, you kind of, at least in many situations, need to think some about original meaning. And I want to just talk about that, and then eventually I will segue into the Second Amendment. So, 7th Amendment says, in suits at common law, the right of trial by jury shall be preserved. Now, my sense is that the dominant view among most people, kind of at least of our socioeconomic class and our location, is that this is not kind of a core human rights issue of the sort we say, I don't care what the text of Equal Protection Clause says. I have real feelings about what equality requires. I think some people have this view, some people have a more populist bent have this view that the Seventh Amendment is part of the palladium of American liberties. I think this is not that common a view, and I don't actually find much to recommend it. I'm uncertain as to what the best policy is with regard to civil trials and juries, but I do think we kind of have to follow the law, right? And there's this text, and I feel we ought to follow the text. The trouble is the text is ambiguous. Suits at common law, what could it mean? It could mean common law as opposed to statutes. I think if most educated lay people or lawyers are asked what means that something is a common law lawsuit, they'd say, oh, it's a suit based on judge-made law rather than statutory law. We could interpret the Seventh Amendment this way. We could interpret it as common law as opposed to civil law. We've heard of common law jurisdictions, England, most of the US, civil law, France, Germany, Louisiana. Maybe if there are lawsuits that require the application of Louisiana law, whether in federal court in Louisiana or in diversity jurisdiction, where that's the choice of law rule, or require, sometimes American courts do apply foreign law, maybe then there should be no jury. Could mean common law rules as opposed to modern innovations. If you've taken first-year criminal law, you've probably heard, well, there's the common law rule and there's the model penal code rule. Common law rule isn't necessarily common law as opposed to statutory. By now, almost all the states have codified all the states have codified almost all of their common law rules, or all of them. Not so much as defenses, but in criminal law, that's what's been done. But we still talk about common law rule. How about common law as opposed to uncommon rules in particular states? There's common law and there's really weird law. You laugh because that can't be right. But why can't it be right? And let me just, for sake of completeness, mention one other possibility. How about common law as opposed to equity or admiralty? You don't laugh, even though to many people that would sound even zanier, right? Equity, admiralty, what's that mean? It turns out that the American courts have adopted that last view. And that is apparently, at least according to what the court has held since around 1830, an opinion by Justice Story, because that's what the original meaning was. That's what Seventh Amendment was understood as meaning. I think if we know that to be the case, and I don't think there's a lot of controversy about that, I find it hard to see why we'd interpret the text of the Seventh Amendment in a way that uses kind of this very different modern view of common law, although it's also around in some measure back then, as opposed to the historical meaning. If we follow the text, because that's what was adopted, that was made law by these authoritative lawmakers, I find it hard to see why it's possible to see, but I just am not persuaded that we should depart from that meaning. And this is, again, an example where I think none of us have very deep ideological commitments here. Just as a matter of applying the text, that seems to me to be right. Now let's move on to qualifications for office. This is from the Maryland Constitution. And I mention this because some of you may know that today is almost my birthday. In a sense, my birthday is very close to today, but also very far. My birthday is actually 2 years away from today. And that's because I was born on February 29th. We're a small but proud group. And that means that I never expect to reach my 70th birthday. Let's say I move to Maryland and become a judge. And then at some point I turn what I would acknowledge as 70. But I say, I'm not going to step down. I haven't reached my 70th birthday. At that point, I'd only reached my 17th birthday and working on my 18th. You laugh, and rightly so, because that wouldn't be a very good, honest judge there. Because it's pretty clear that 70th birthday doesn't really mean 70th birthday. It means age 70. It's just a common way of saying it. I don't think we need a lot of heavy-duty originalism, of course, to figure that out. It's our understanding of the way text is interpreted now and probably was back then, especially since there's absolutely no sensible reason why they would want to have a special rule for leap year babies like me. So I give this as an example of something where I don't think we need original meaning because there's so many other things. In fact, if anything, this is kind of would be an argument almost by pawn. I say, 70th birthday, well, I haven't reached one. That's obviously a joke. And we may not need original meaning to determine that. But as I'll mention shortly, I think at some point we start, on that continuum, we start getting there. And let me have an excursion into the Establishment Clause. which of course says Congress shall make no law respecting an establishment of religion. This is from Justice Stevens in County of Allegheny, the menorah case. It is also significant the final draft of the Establishment Clause contains the word respecting. Like touching, respecting means concerning or with reference to. So far, I'm entirely on board. But it also means with respect, that is, reverence, goodwill, or regard to. Taking into account this richer meaning, the Establishment Clause, in banning laws that I omitted a word, or maybe included a word. Bans laws concern religion, especially. I misread this. In banning laws that concern religion, especially prohibits those that pay homage to religion. I respect Justice Stevens in many ways, and this in his sense of the word respecting. But I don't think this was a sound argument on his part. Again, it's an argument by pun. I think just in context, among other things, it doesn't say shall make no law respecting religion, respecting an establishment of religion. So, under his own vision, it's no law that expresses respect towards an establishment of religion. That seems very odd here. But, and again, here I think original meaning might matter. Imagine that he had trotted out some evidence that, in fact, at the time, respecting an establishment of religion, contrary to our understanding of this now, meant, well, it was showing respect to establishment of religion. I would have to change my views. I would have to think that's a more plausible argument. Let me move on to a different qualifications clause, a very famous one. No person except a natural-born citizen shall be eligible to the office of president. Now, let's say that 2 years from now, in December of 2016, I get a phone call, and they say, Wallach, the Electoral College has met, and they have elected you President of the United States. A highly implausible hypothetical, but work with me for a moment. As you can tell from my heavy Russian accent, I was born in Kiev. I was born in Kiev, the capital of what is now the Ukraine, back then Soviet Union, really Russian Empire. And I, for many, many reasons, but in particular for this one, I would feel I cannot accept that office. Now, let's say I were to say, no, I really want to be president, and my mother tells me that I was delivered through natural childbirth, not through a cesarean section. You laugh, because that would be an unacceptable mode of argument, it seems for me. And again, it would be constitutional argument by pun. I think I could not honestly take an oath of office to support and defend the Constitution of the United States if I knew that I was not eligible. But how do I know this? And incidentally, this is an issue, of course, that came up not just famously with regard to President Obama, but it's coming out now with Ted Cruz, came up with regard to John McCain. This is still a contested issue. And I, by the way, think all three of them are natural-born citizens. But how do we know what that means? I mean, I think what it means is a citizen who is a citizen from birth, as opposed to a naturalized citizen. But it's an interesting question, what it means. Now, we could just say we're just reading the Constitution today. Forget history. That's what it should mean. But why? I mean, one possible answer is we want to read it as narrowly as possible because we think it's an unfair provision. I think it's unfair. I don't stay up nights worrying about it, but I don't think it's fair that somebody like me who came here at age 7 couldn't be president, or my brother who came here at age 2 couldn't be president. But still, I take it, my sense is that people really do think that a president ought to follow these provisions, whether they're fair or not. And that it's unsurprising, I think, that a good deal of the argument turned on what it was that the framers understood this provision to do. Because if a natural-born citizen really does mean, for example, as in the case of Ted Cruz, somebody who is or President Obama, somebody who is the son of 2 citizens, some people have said that, then neither would be eligible because each of them had a parent who at the time was not a U.S. citizen. And I do think that, again, if we saw something that made clear that that's what the phrase meant at the time, here maybe people might find this more controversial than with the Seventh Amendment. I should think that that would matter a lot. Again, if we're following this phrase because it's in the text, I should think that we should also care about what the text was understood as, because the only reason, just like with the Seventh Amendment, if we care what suits what common law means, and common law is ambiguous, or here today, natural-born citizen isn't even so much ambiguous. It's just not a common phrase in ordinary use these days, as opposed to common law, which at least is in some measure. I think we ought to care about how it was understood. If it was a legal term of art that at the time was clearly understood to mean X, Y, or Z, that, it seems to me, becomes part of the law. Again, if we want to set aside the text, perfectly fine. But if we want to focus on the text, especially one that hasn't been encrusted yet with precedent or clearly well-established practice liquidating its meaning, I should think original meaning is relevant. So now I have 5 minutes left. Let me turn to the Second Amendment. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. That's what it says. But what does it mean? So let me tell you a few things that I think we can say it means, at least presumptively, without much reference to the original meaning. So for example, it's the right of the people. Some people say, well, it's the right of the militia. I think it's pretty clear. If you look at the text, it says the right of the people. You might dispute whether it is the right of the people as a collective or as individuals, but it's the right of the people. That's, again, something that maybe we might think that that original meaning or something else should lead us to alter our judgment, but at least presumptively that's what the text seems to mean. Again, if you care about the text, and maybe you don't, but if you do that, we should focus on that. Well, let's look at something a little bit more ambiguous. What about security of a free state? Now, that could mean two things. One thing it could mean is security of a state of the Union that is free of federal oppression, free of federal control. That's a plausible understanding of state. Certainly the way state is generally used, mostly in the Constitution, is to mean state of the Union. It could mean what today we might call a free country, which is to say a country that assures liberty to its citizens. And it could be at the individual state level or the national level. In fact, state is sometimes used to refer to foreign states, which means countries. Now, I did some research, and I found, and people may disagree with me this, but I found that if you look at the sources that the framers were reading, the overwhelming majority, well over 90% of all references to free state, including in Blackstone and Montesquieu and other sources which are especially influential, meant free country. So if people were talking about something as a free state, what they meant is as the opposite of a tyranny. Now, again, maybe we, for whatever institutional reason, should want to say the Second Amendment does not secure an individual right. Perfectly plausible. Or for textual reasons, despite that, you might say it doesn't secure an individual right. Perfectly plausible. But I do think if indeed there is this evidence, and I think it's pretty powerful, that free state means a free country, to say today, oh, well, what it really means is of a state of the Union that's free of federal oppression, I think is something like interpreting the Seventh Amendment to view common law as opposed to civil law. Thanks. It is something that doesn't do violence to the English language as such, but does suggest that we're following the text in a way that's kind of a pun, in a way that just takes advantage of the fact that the meaning of these phrases, quite independently of our understanding of constitutional meaning, has changed over time. And I don't see any reason why we should use this modern or this alternative past definition. I think, so those are particular things we might look at particular words. What did militia mean? Does it mean National Guard? Did it mean the entire adult male or large chunks of the adult white male citizenry? Basically, there was an age limitation. Turns out to be pretty clear it meant the adult white male citizenry. That does seem to have been the case. Again, I think if you're going to care about the text, that should matter. Then you might also want to look a little bit about how similar things were talked about. For example, I think the really important thing is the right of the people to keep and bear arms. What is the right of the people to keep and bear arms? Well, it may matter that this was framed on the English Bill of Rights, right to have arms, to be sure, with more qualifiers there. That didn't seem to be a federalism provision. You didn't have federalism provisions in England. That didn't seem to be a right of the militia. It did seem to be the right of individual subjects, Protestants, to be sure, only in England. Likewise, you might look at Justice James Wilson, who was writing around the same time his lectures. And he was talking about how self-defense, he wasn't talking about the Second Amendment, he was talking about the Pennsylvania right to bear arms. Self-defense was part of the great natural law of self-preservation, expressly recognized in the Constitution of Pennsylvania, the right of the citizens to bear arms in defense of themselves shall not be questioned. Now, maybe this is not open and shut. Maybe there are other reasons to think maybe bear arms meant something different. But again, I would think that this is the kind of evidence that should be pretty helpful for us in understanding whether the right to bear arms had a self-defense component. So let me close with one other thing. I just want to put up this little slide because I wanted to find this language, and I wanted to find good text of it. And I found that Robert Pattinson and Kirsten Stewart were fighting over custody of a bear. This is the rare situation where Google actually led me astray. Fortunately, I found the text, and I won't go into much detail, but this is an early gun control statute in England. This is in the early 1700s, where they wanted to ban possession of various arms by Scotsmen. And they say that in these counties, it shall be a crime to have in war custody, use or bear, broadsword or target, pistols or a gun. I'm pretty sure it wasn't a crime to bear in the military sense, made this way, because already bearing arms in a military sense without permission of the king was a crime called treason, had very serious penalties. I think this was an early gun control law that talked about people having and bearing guns. That too, I think, should give us some sense of what the right to keep and bear arms meant by a sense of what prohibitions on that, on the bearing of arms would be. So with that, I close and I turn to Mike.
All right. Well, thanks very much. Thanks very much for having me here. I don't have fancy slides. I don't even have a computer, but I do have a yellow pad of paper that will hopefully sort of keep me on track. I am not going to talk about the Second Amendment at all. I'm also not going to talk about foreign affairs or anything I really know anything about. But I am going to talk about two cases where the Supreme Court tried to use history and sort of give an assessment of how they did. The first one I'm going to talk about is United States versus Jones from 2012. This is sometimes called the GPS tracking case, although I prefer to think of it as the case where the Supreme Court demonstrated it didn't know very much about Sherlock Holmes, which I'll explain in a minute. It's also sometimes thought of as the case where they attempted to decide what the founders thought about GPS tracking, which would have been a puzzle. But I think properly understood, it is a case asking what is a search, because it's a Fourth Amendment case. And the question was whether what the police had done was considered a search. What they had done is they had put a device on the defendant's car that allowed it to be tracked. And the question was whether that amounted to search that triggered the initial question of whether it was reasonable under the Fourth Amendment. So Justice Scalia, writing for the majority, states the general rule to be as follows, quote, when the police physically occupy private property for the purpose of obtaining information, then that's a search. His citation for this is only Antic versus Carrington, which is a famous search case from 1765 from England, which is often recognized as an antecedent to the Fourth Amendment. And so, in some sense, reasonable to the case. But the problem with Antic versus Carrington, and sort of tapping into the whole history behind Antic versus Carrington, is that case was about land. It was about a search of someone's home, and that's made very clear in the case itself. For example, the court states as a central proposition, quote, "No man can set his foot upon my ground without my license." Or later, that the police will be liable to an action for even treading upon the soil. Well, there was no treading on the soil going on here. Scalia then goes on in the case to posit a constable concealed in a coach as the 18th century analog, and he says there is, quote, "no doubt that this is a trespass," without citation. Now, this, in response, this gives Justice Alito in dissent the laugh line of the case, where he says, "It is hard to imagine this, as it would require, quote, either a gigantic coach or a very tiny constable." But in fact, I think Alito perhaps had a stronger argument, which he toyed with but didn't make as central as I would have liked to have seen. What he says is that actually this case is about trespass to chattels, not about land, which is what Antic versus Carrington was about. And he says that the rule at the time was that it was a trespass to chattels if there was a violation, again I'm quoting, violation of the dignitary interest in the inviolability of the chattels. It's not clear what that means. He then goes on to say, well, under modern law at least, a, quote, harmless or trivial contact with personal property is not a tort, and therefore, I assume impliedly, not a trespass, and therefore not a search. So what the case seems to come down to is whether a sort of incidental contact with with personal property of a coach, perhaps, was considered a search. Now, I think actually that, put that way, it's fairly easy to translate the question in United States versus Jones into something that could be historically manageable. One of the popular accounts of this case is that it just doesn't make sense to apply originalism to a case like this because there's obviously no GPS tracking in the 18th century. But I think there is a way to translate this back into something that is a historical question. And the question is then how to answer it. Well, here's where Sherlock Holmes comes in, a little bit at least. With regard to the tiny constable, I think Justice Alito simply hasn't been reading his Sherlock Holmes, because if he had, he would know that one of Sherlock Holmes's practices was to follow people, among other things, by perching on the back of their coach to see where they had been. And he does that, I believe, in particular case called the Cornish Horror, in which he discovers what the bad guy's been up to in precisely that way. So it's not as implausible as Alito suggests. But on the other hand, I also think they have the wrong analogy, because this is not the case that the policeman is hiding in the car. The policeman has only put something on the car that identifies it. But why could you not ask the question, well, what would have happened in the 18th century if the police had put something on a coach that would have identified it? Would that have been a trespass? Would that have been a search? Now, I don't think it's not really an ahistorical question. You can imagine this because, again, Sherlock Holmes engaged in such a thing. In The Sign of Four, he contrives to have the suspect's wagon driven through creosote, which is a nasty, sticky, smelly substance, and then uses a dog to track the carriage to see where it went, and which ends in disaster when the carriage crosses paths with an actual barrel of creosote. But never mind that. And now I realize, of course, that Sherlock Holmes is not a state actor, and further is fictional. But nonetheless, I think this suggests that you can imagine the question translated back into the 18th century. Would it have been a search or a trespass, if you want to put it that way, to put some sort of identifying mark on a private carriage in order to identify it and to make tracking of it easier? The problem is that we don't have any answer to that question. Now, it's possible that history would supply an answer, but I think it unlikely that the justices would have the capacity to investigate that on their own, and the briefing didn't provide them any assistance in this case. So I think Scalia ends up falling back on what I think is in effect a default rule that he's created, that any time they have any infringement upon private property for the purpose of obtaining information, that it is a search, and therefore finds a search. But I don't think there's any historical basis for that rule either. And so what we're left with, I think, is perhaps a manageable question, but not any actual answers. And this line of thinking, then, the Scalia-Alito back and forth continues on into Florida versus Jardines in 2013, where the question is whether a dog sniff at someone's front door that identifies marijuana is a search, and Scalia says that it is, because it is a physical occupation of private property for the purpose of obtaining information. And Alito says it's not, because the police would have an implied license to come onto the property as long as they didn't linger. And again, I think this is something that can be translated into an 18th century question, but the justices don't provide any answer. Alito does rely on a 1318 Scottish statute about dog tracking, but it doesn't really seem to go to the question at hand. And his central point is, Alito's central point is, that Scalia hasn't shown any cases that show that dog sniffs or other kinds of dog tracking in this context were considered searches, and Scalia responds, well, that Alito hasn't shown any cases in which it was considered not a search, in which it was considered okay. And the question, of course, boils down to what the default rule ought to be, and who bears the burden of showing a historical practice that contradicts the default rule. But the problem is they don't have any historical basis or other basis for creating the default rule apart from Scalia's declaration as to what a search means. And so I think we are left on those cases with sort of a possible historical framing of the case, but no actual answers in a historical sense. Let me now turn to another case, which doesn't involve guns, but it does involve virtual guns. So in that sense, it's sort of like the Second Amendment. That's Brown versus Entertainment Merchants Association from 2011, which is the question of whether violent video games can be banned, or rather whether the sale of them to minors can be banned by state law without infringing the First Amendment. Scalia again writes the majority opinion, and he starts out with the statement that the First Amendment provides a general rule against content-based restrictions on speech, which we have taken things such as movies and video games to include. And then he says there are exceptions that arise from historical practice, such as obscenity and so forth. And concludes that in the absence of any historical warrant for such restrictions, then they must be struck down. He then finds that there is no historical warrant, based on the question, not, of course, whether violent video games were outlawed. This is Alito gets another laugh line here in the oral argument where he says, I think Justice Scalia is trying to figure out whether James Madison played violent video games. But I think that's not what Scalia is trying to figure out. He's trying to figure out whether there's a pattern, historical pattern of restricting speech because of its violent content. And here he does have some assistance from a historically based brief from the Cato Institution, which I don't vouch at all for its history, but it did show, it purport to show at least, that although there had been significant concerns about violence in dime novels and what have you, and their effect on children, that in fact there hadn't been any legislation against this sort of violent speech. And therefore Scalia concludes that's the appropriate historical analogy. Because it was not banned, it does not create an exception to his default rule, which I think he has derived not from history but from precedent and constitutional doctrine. This case is particularly noted because the Alito writes a concurrence, but the principal dissent is by Justice Thomas. And Justice Thomas engages in an elaborate historical exegesis of the relationship between children and parents, starting really all the way back with the Puritans, if not the dinosaurs, and carrying on through the 19th century, in which he concludes that parents had or were regarded to have, or regarded as being supposed to have, significant control over their children. And from this sort of unstartling proposition, he then concludes that the framers could not possibly have understood the free speech clause to include an unqualified right to speak to minors, and thus he would uphold the California statute in question. It's an excellent example of the use of history, except for the fact that it doesn't answer the question that's being asked, because nothing in any of his elaboration of what the supposed rights of parents were says anything to the particular legal question, which is whether laws that banned speech on the basis of its violent content were thought permissible. All it says, unsurprisingly, is that parents at least believed that they ought to have significant control over their children, a view which, as a parent, I very strongly endorse. And he did have some discussion of Thomas Jefferson's approach to raising children, which somewhat surprisingly he found that involved very close supervision, which I had some doubts whether that was actually true or not, but he does assert it. But nonetheless, none of this goes at all, in my reading, to the question at hand, which is what was the status of laws with violent content. So I think here Scalia has a somewhat better time with the argument than he did in Jones, because he is successfully, well, at least sort of within sort of regular legal conventions that allow it that require a rule to be based on something rather than just your declaration. He has successfully found a rule, a default rule, that is that content-based speech is restrictions are prohibited. And then he is asked whether there's a historical question and whether there's a historical exception, and he didn't find any historical exception. And the burden in that sense has then been shifted over onto Thomas and dissent to come up with a historical exception. And in that sense, I think Thomas spectacularly fails. He has this long discussion, which is sort of interesting in its own way, but does not at all address the project of finding a historical exception. He ends up at the bottom line in the language that I just quoted in something that seems I regard as just simply speculation. So that's how those cases end up. And what the conclusion, it seems to me, is that it makes a lot of difference what the default rule is going to be. Who gets to decide what the default rule is? And then once you have a default rule, it may well be that historical practice can either show that there is an exception, or in contrast, not find an exception. It's hard to prove a negative, but just the failure to find it once you have a default rule would give you the answer. And I think this all seems to be a manageable project, at least in theory. But as these opinions suggest further, I think it's a difficult project to suppose that justices of the Supreme Court could undertake on their own. So I think my bottom line conclusion is that this is something that they are going to need a lot of help, and perhaps this is just a full employment project for historians, as Jack has alluded to, but they're going to need a lot of help if this is going to be a manageable project, because otherwise we're just going to end up with Justice Scalia signing Enning versus Carrington and think that has something to say about whether the police can touch your car or not. I was going to say a word about separation of powers cases, because that's the one I actually know something about, but I now see I'm out of time. And in any event, my conclusion in general with respect to the separation of powers cases is that the Supreme Court actually has not made much use of history except by very general reference to historical propositions that seem to have been established, or which the Supreme Court regards as having been established in general, and I think implicitly, although I would like to see more citation of scholarship in this area, but established by the scholarship of separation of powers, but where the court doesn't actually engage in a lot of historical inquiry. And to some extent, I think that use of history may actually be more fruitful, because it doesn't involve the Supreme Court in elaborate historical inquiry, which I have some great skepticism that unassisted they are in a position to engage in. So I'm not sure whether that's an endorsement or a non-endorsement of the use of history in particular cases at the Supreme Court, and I will leave that for your own conclusion.
Thank you, Mike. Well, we have about 25 minutes for conversation. I have a couple questions I wanted to put to the panelists, if that's okay, and then we'll open it up. I guess this is for Jack and Eugene. How would you describe the disagreement between, speaking about Heller and the Second Amendment generally, the disagreement between the majority and the dissent, or go to the scholarship, the views in the scholarship? Is it a disagreement about what level of generality at which you ask the question? We heard something about, textual definitions versus Jack's what they thought they were debating. Is it a difference between looking at what the framers, the Philadelphia framers, the congressional ratifiers versus the state ratifiers, or is there some other difference, and then speculate on the implications of that?
Well, I guess what struck me when I look at the two opinions is that, it seems to me it does illustrate this kind of pronounced shift in what originalism has come to mean. That's to say, there was a big body. It's what Glenn Reynolds called the standard model. There had been a significant body of writing by people, actually, I think in many cases, just directly supportive of or supported by the NRA, which did tell a kind of historian story. I mean, I think when I looked at this stuff, it was really pretty thin in terms of how it dealt with the evidence. And in the meantime, the movement of originalism, which Keith talked about at lunchtime, had gone very profoundly in the direction of taking the linguistic turn. So it wasn't, the kinds of historical references that appeared, I think, earlier in the kind of pro-individual right literature. It seems to me that pretty well dropped out of DC versus Heller in the final product. So, so I thought our side, obviously, or, our brief in particular, was strongly historical, on the ground stated, namely that I don't know if we have, I don't know if as historians we're entitled to have a theory of constitutionalism, but we certainly had an approach to it, and, implicitly and explicitly we argued there's some specific set of reasons why this clause or this article was added to the Constitution. Again, I think Scalia, for his own purposes, moved pronouncedly away from that. So the history essentially dropped out, except it appears that maybe not unlike what Gene was doing. Gene has to speak for himself, obviously, but there is a lot of evidence of particular uses of keep and bear in the 18th century. I mean, kind of like your Scottish slide, for example. I think from a historian's vantage point, I think in some ways this echoes many things that Helen, was saying yesterday. From a historian's vantage point, that's just not enough. I mean, you need to have some compelling story about what people thought they were doing, and a set of linguistic references, interesting in and of themselves, would not give you a satisfactory account, or a whole or comprehensive satisfactory account of why it was there. So to me, that's what makes the case most interesting.
So, two thoughts on this. One is, I think what the majority thought of itself as doing is saying, look, there is a particular legal text that was enacted as law. This legal text did not arise in a vacuum. It had antecedents. Those antecedents had been interpreted in various ways beforehand. Then it was interpreted in various ways afterwards. The court also looks to post-ratification era stuff. And the right to keep and bear arms seemed to be part of a tradition of an individual right, not an unlimited right to be sure, but an individual right and not a federalist right. And there were all sorts of pieces of evidence. One of this, the English Bill of Rights. Other is the way that things were understood by Justice Wilson around the time. Justice Wilson, person of non-trivial significance in stories about the framing era, by later cases, by state constitutions that adopted similar provisions. And they, I think, were a lot more interested in that evidence as to what this legal phrase generally referred to than what it is that the framers and ratifiers of the Bill of Rights were interested in during those two particular years, what their goal was. To the extent you ask Scalia how much you care about the goal of these particular people, he would say, not that much. What I care about is the meaning of these words. And the meaning of these words, if you look at the big picture, would be fairly well understood. Now, the dissent, I think, also disagreed with Scalia, the meaning of the words, but I think that was part of the difference between the two. Here's the other thing that I didn't really see much of, even in the dissent, is a living constitutionalism. Here's what I think would have been for a living constitutionalist. If the living constitutionalist really approached this issue, here's what I think he would have to say. I don't care that much about original meaning, but I want to see how the amendment has been understood by other important actors throughout American history, especially recently. He would have seen that 44 of the 50 states had right to bear arms provisions in their state constitutions. 40 of them, at least, clearly individual right to bear arms provisions, clearly aimed at self-defense, either through text or through interpretation. He would have seen that Congress and the president had repeatedly, in recent decades, endorsed the individual rights view. To the extent he cared about polls, he would have seen that there was 2-to-1 to 3-to-1, depending on the poll you look at, support for the individual rights view. To be sure, federal courts of appeals had been dominantly, throughout much of the 20th century, against the individual rights view. But that was basically, in terms setting aside scholarship, which I think living constitutionalists probably don't care that much about because we professors are appointed by no one and confirmed by no one with any legal significance, really lopsidedly the judgments of other important institutional actors in the American legal system all pointed towards the individual rights. So yeah, I know maybe you might say, well, great. Originalism is very bad. This should have been the approach, same result, but at least a more sensible approach. Or maybe you'd say, well, no, I think living constitutionalism cuts in favor of a states' rights view or militia rights view, although I'm not sure where you'd get that. Or you might say, well, I'm really not a living constitutionalist either. I think that the court should leave legislatures with flexibility to make important decisions, or I just think as a moral matter, right to keep and bear arms is a bad idea. You can imagine that. But if we were talking about what is often put out as the main alternative to originalism, which is living constitutionalism, my claim, and I'm happy to debate this, but I think I'm pretty solid on this, my claim is that sound living constitutionalism would have reached exactly the same result.
Yeah, I think that's the great irony of the whole gun issue, which is it ostensibly purports to be about these deeply held historical values rooted from the 17th century to the 18th century. In fact, it's an enormous tribute to living constitutionalism, to popular constitutionalism. Story says, most Americans do think that,
I'm not saying the majority said that. That was their rationale.
No, I think, right. No, I think independent of the decision. I think the outcome actually is in strong consistency with that view. I think with the qualification that most Americans also support the idea of gun regulation while believing in the individual right.
Yeah, and Heller left plenty of room for that.
And which Heller did, right? Yeah.
Yes, sir.
Question for Professor, is it Volok?
Volok, yeah. Oh, whatever.
My Ukrainian is rusty, but
well, in Russian it would be Volok, but I do not insist.
I thought your illustrations were extremely interesting, which I guess is a word in favor of PowerPoint. But do they lead you to a specific philosophy or theory to interpret the Constitution? And if so, what?
So my tentative view, and those who are familiar with things that I've written will acknowledge I'm being quite candid that I'm not a constitutional theorist by any means. I usually write about doctrinal questions. Occasionally I write about a few historical points and leave it to others to decide and to what extent they should be relevant. But generally speaking, I'm not a constitutional theorist. But my tentative judgment is, to the extent you care about the text, as opposed to precedent, as opposed to ethical argument or whatever else, or structural argument or what have you, you should care about the text as it was originally understood. Again, except insofar as precedent has taken us down a path which we're not going to go back on. And the reason is, I think if we care about the text, generally speaking, and I realize what I would say is somewhat controversial, but if we care about the text, we care about it because somebody enacted it, because it's the law. And if there's some uncertainty about what the words mean in that, I think the most sensible approach to filling in that meaning is filling in the meaning as it was understood when it was made law. Incidentally, a very orthodox view in a wide range of court decisions from state courts. State courts routinely say this is the way that they interpret, say, ballot measures or old state constitutions and so on and so forth. That's the limit of what I am saying, and there may be perfectly good reasons to ignore the text in various contexts. But if we care about the text, I think we should care about it as it was understood then, rather than as linguistic change that often has little to do with legal principles causes us to, at first glance, understand it today.
Yes.
Well, I guess I want to take up some of what Eugene said, because I have to say it struck me as if I was writing an article, how not to do things with historical text, the arguments you made would be exactly the way I would illustrate it. So, for instance, when you talk about the militia and the people, it's just historically not true. There's an incredible debate about whether they should have a select militia. What you do and what a lot of people have done is, for instance, to take a rhetorical text, like an anti-federalist text, give that greater weight than the Constitution's own definition of what the militia will be, or any of the first Congress's debates over the future form of the militia, or any of the state militia acts. So it's interesting that we hear this talk about it's a legal document, but when it's convenient, we go to a rhetorical text published in a newspaper and give that greater weight than we would give to legal texts. Then you talk to the Declaration of Rights. I think the standard argument of most English constitutional historians is the Declaration of Rights, besides limiting things to Protestants and also limiting to class, actually has that vital last clause that you don't mention, which is as allowed by law. Also, the very same Congress, very same Parliament that adopts the Declaration of Rights very expressly considers a bill that will allow people to have firearms in their home and rejects it, as Lois Schwar has argued, because it will tend to arm the mob. So, and then when you give the example of, bear arms, a couple of isolated examples, I mean, sure, I don't think anyone denies that if you look at every use of bear arms, which actually several historians have done, 97% of them fit some kind of military related. And if they're 97%, it's easy to pull text out of context. But I think Jack's point is, if we're really going to make honest claims about what it meant to either the average person or a large percentage of people, how can you justify pulling the 3% and making that dispositive and ignore the 97%? So I think this is why historians find the practice of originalism so deeply troubling, because there's no clear methodological rules that are justifying particular pieces of evidence. It's kind of like all pieces of evidence are created equal. There have to be rules about how to weight them and how to, I mean, for instance, when you talk about the English Declaration of Rights, Jack knows Madison. Madison didn't think that the English Declaration of Rights is a very robust protection for the right to bear arms, right? He says that expressly. St. George Tucker also says that. So how is it that the founders didn't think the English Declaration of Rights was actually much of a protection, but now, 200 years later, we can say, but everyone knew there was a pre-existing right protected by the English Declaration of Rights. I think that's why we have a problem, because it's not possible. I mean, either we're going to have rigorous rules of argumentation or not, but I don't think you can make those kind of arguments, and they just don't stand up to historical scrutiny.
So I think you're just mistaken about the militia provision. I was not in no way relying on any newspaper accounts. The Militia Act of 1792, which is probably our best sense, at least my best sense of what militia meant at the time, basically says, if I recall, all white male citizens age 18 to 45 with some categorical exclusions for particular professions. You say that where the Constitution defines the militia. I don't see the Constitution.
Around that, because they came very close to adopting the select militia.
So the militia is defined in the Act as 18 to 45. If you say militia means something different, I think the burden is on you to show that it's different. You say it is defined in the Constitution. I don't see it defined in the Constitution. There was talk about select militia, and it's true, select militia is a subset of the entire militia. But when militia is used, it generally refers to the adult white male citizenry of that particular age range. You mentioned the right to have arms. There's no doubt that the right to have arms in the English Bill of Rights is qualified in various ways. It's limited to Protestants. It is as suitable to their station and as allowed by law. Now, obviously, America is a different place. America rejects religious tests, rejects the notion that different people have different stations of titles of nobility and the like, and, well, of course, is allowed by law because the English tradition is not to have a constitution that limits what it is that Parliament could do. That was the English rule. The American rule omits that. So there's no doubt to me that the right to keep and bear arms is somehow connected to the right to have arms. I think also the omission of the qualifiers is telling in some measure. I don't think that it could be the right to have arms is the right of individuals, and the right to keep and bear arms now all of a sudden the rights of the militia or the rights of the state. But I do think it's quite possible that certain qualifiers are omitted. The framers certainly wanted to preserve some ancient rights, but they also quite clearly wanted to remove some of the limitations on the ancient rights. Now, the last thing you say is about bear arms. When you have specific laws that talk about keeping and bearing arms or prohibiting people from having and bearing arms. And those are what today would be understood as gun control laws, laws that deny people the ability to have guns for self-defense. It seems to me that when you then have a provision about keep and bear arms being a right, that's a way of repudiating those laws, at least in some measure. And it isn't just me, and James Wilson says the same thing. That tells us something about it. So obviously you and I disagree on the history, but I think that the majority is the one that's doing the better history here.
Yes.
Yeah, just
Mike, go ahead.
Yeah, just real quickly, I just wanted to say, without taking any sides on this, because I'm not going to say anything about the Second Amendment, but there's sort of been some suggestion that sort of historians do something different, or from legal analysis and so forth. And the only comment I just have on the exchange that you've just heard between a historian and a lawyer is that it sounds to me just like what lawyers do when they're interpreting historical text. And that the questions that Saul raises, which are extremely good ones, are exactly the same kinds of questions that I, as a non-historian, would raise in an attempt to understand a legal text. So I guess without getting into the details of this particular case, I would sort of push back against the idea that there are some different enterprises going on here. It sounds like we're on the same page. We're just disagreeing on how the words were used at the time.
Why don't you go? Yes.
Hi, this is a question directed at Dr. Rakoff. You pointed out that one of your objections to kind of the original public meaning sense in Heller was that, who original public meaning to who, right? And so I guess I have a few questions. One is, so are you very clearly advocating original intent rather than original meaning? Secondly, how does that solve that problem? It has the same problem, which is intent of who. And then I guess third, if it is intent to who, and you think somehow that helps, how is whoever that who is, how does that somehow larger than, say, the who of the people in Pennsylvania who already have a sense of what RKBA means, in their own state constitution? I mean, it seems kind of plain in the text.
Well, it's less plain than you think. So that's why I wrote a book on the subject. Which I clearly have not. Yeah, and so my argument is, it goes something like this: we have disputes about the original meaning of the text. One, two immediate guides to interpreting that would be to do your best to figure out the original intentions of its authors. The framers, to look at the ratification debates, do your best to ascertain the original understandings of the ratifiers. When those are inadequate, you would then do two further things, right? Actually, in all cases, and I try to do this, by the way, in the brief. So one is to look in part at the kind of what I call the zeitgeist, or the deep intellectual experience. So Blackstone and others, Locke come into play, and then, but also I think very consistent with my experience as a historian, being first and foremost a political historian rather than a legal historian or even a constitutional historian, to look at the kinds of experiences the revolutionaries had. And to ask, what kinds of inferences can we draw about their purposes and behavior on the basis of the fact that they had been A, active revolutionaries, and B, had been making constitutions at different levels of government. So I actually try to work out a historian's method to think about originalism. I did not mean it to be legally dispositive, and I think, again, building on Helen's excellent remarks from yesterday, there are so many reasons why you would want to draw disparities between what historians like myself or Saul or Helen would strive to do and what you could reasonably expect of lawyers. I'm not so foolish or naive in my advanced age, which is approaching the 70 that I guess Gene will never reach. To think that this is going to work for courts. But the larger point I want to make here is, and we're going to try to wrap in 5 minutes. So the larger point I want to make here is, I want to start thinking about what would it mean to have justices engage authentically with American constitutional history, broadly defined, for rhetorical and perhaps for analytical purposes. And I do think, as I said yesterday, I think if you think about Shelby County, if you think about the two very different attitudes towards the history of race in the United States, illustrated in Justice Ginsburg's dissent and in Justice Roberts' majority opinion, and to have both jurists articulate more vigorously than they do what their conceptions of American constitutional history are, have been, or where the issue fits in that story, I think we might be better off as a republic in that sense.
I believe you are next.
I have to say, I'm increasingly confused as I hear the debate go on, the questions asked being answered. On the one hand, I think Mike Ramsey is right that the arguments that sort of we're each making to each other are sort of arguments of the same nature. We're trying to figure out how best to understand this text. On the other hand, there are statements that are made that sort of what we're not trying to do is to figure out the law. That's a separate activity from telling the history of the amendment. I just took a little time during the talk to read through the brief that Professor Rakoff wrote, and it actually is a very different activity, I think, than most of the briefs that I read while clerking, in part because the one question one often asks when you're clerking is, what rule of law did this particular enactment lay down? And that is not the question that the brief answers or is sort of clearly designed to answer. It tells a very elegant historical narrative of what occurred to cause this enactment to come into effect. But the only statement I could really pull out that seemed to be answering the rule of law question is the amendment as revised would still assuage anti-federalist concerns by stating a principled commitment to the value of the militia, but it would not hinder Congress in using its best judgment to determine how to organize, arm, and discipline an effective militia, which sounds very close to saying no rule of law. And of course, there were provisions that enacted no rule of law, things like the Virginia Declaration of Rights, so like all power is vested in the people, and sort of purely declaratory sort of things. But it seems like what one normally looks for in a legal brief is a statement like, yes, that's what it did. It laid down no rule of law. It's purely declaratory. That isn't necessarily the headline of the brief. And maybe there are good rhetorical reasons for it not being the headline brief, but it seems to me that we're going to keep talking past each other if we're not totally agreed on which activity we're actually trying to do, whether we're trying to historically explain the enactment of an amendment, or whether, given those facts, we're trying to state what rule of law that amendment produced.
Yeah. Steve, I'll tell you later. I think we'll get one last question.
Well, but
Okay.
I'd love to hear the answer.
Well, okay. So,
only have 2 minutes, though.
So, Steve, really briefly, I don't think it's the historian's job to lay down or even identify rules of law. I think we're there when, on the occasions when you write a brief, you're there to try to provide as much historical context for the court to think about, so they will have a different basis for reflecting analytically on the issues. Andrew. Well, he's wrong for other reasons.
One last question.
How you doing? Thank you all for coming out. So quite a few authors have cited that Madison's initial draft of this amendment kind of intended almost an individual right, according to some of these authors. And also, as we know, he originally intended to kind of insert these amendments where they most logically seem to fit. And according to one author, he says that rather than putting it under Section 8 of Article 1, dealing with the militia, it would go under Section 9 after Clause 3, that section basically kind of limiting Congress's powers. And also there's the discussion of the Bill of Rights was not, granting any new rights. It was kind of just establishing what was already there and held. So given your expertise on Madison, what do you think those, references mean about his intention and also the mind state of people at that time frame regarding this amendment?
Yeah, that's a great question. Well, I think the first one, I read Madison's original draft of the amendment to be, very much about, to link it to the militia military context. I mean, the sequence changes in the revision. The reference to the Quakers drops out, but it's still very much, it's oriented to the militia question, not to the personal right one. The second thing I'd have to think more about, to be honest. I mean, you're right. It's a big part of Madison's strategy to try to not to have a separate Bill of Rights, but to insert the articles at the point where they would be most relevant. Think of it if it's a restriction on Congress. Well, I think the point there was to reassure anti-federalists that when Congress acted in terms of dealing with the militia, it would be respectful of the value of maintaining the militia as an institution. I mean, I think that's a big part of the political ambiance behind it. The militia would continue to survive. States could still support it on their own.
We have more questions, but no more time. Let's thank the panelists.